It was the question Larry Walsh had been asking for decades.
How could I have got a criminal conviction at the age of 2.5?
For years, he says the authorities used a criminal record he knew nothing about against him. The mystery consumed the Tongarang man until he applied for his criminal record, and what he found has left him with more questions than answers. The first charge listed his removal from his family when he was only 2.5 years old. His stated offence was having needed a care and protection application while his sentence was being committed to the care of child welfare services. His removal from home was also listed as a conviction on a Victorian police criminal history sheet, leading to a life of tainted reputation.
Someone reckoned I'd end up in jail for murder. Someone reckoned I'd end up in jail for armed robbery. That's what the view was of Aboriginal people with criminal records.
His story triggered an investigation that found it was standard procedure for children to get a police record for being taken until the late 80s. Documents published by the Victorian Children's Court highlighted a systematic failure to distinguish between children who needed protection and young offenders. This system deemed babies, children and young people in need of state protection to be criminals, with this appearing on their police criminal histories. Bronwyn Naylor, a law professor at RMIT University, conducted part of the research.
Until the late 1980s, the Children's Court managed both child protection matters, which is welfare matters, and also criminal matters. So the orders that they made appeared on the same document. So there was a real blurring of the powers of the court.
She says this early police record could have caused many to be punished for crimes they never committed.
So this was a real surprise, that there was that blurring or that combination of protection matters and criminal matters. And we really feel that this has significant consequences for people, literally in terms of what their criminal record looks like, but also in terms of how they feel themselves.
Larry Walsh is adamant that having a police record from such a young age has adversely affected his life. His first memory of being accused of criminality was when he was just 8 years old.
I spent most of my childhood and half to 3/4 of my teens in a system that refused to recognise me as a person.
He says his discovery has raised questions for an entire generation and is calling on others who are removed to contact their local Aboriginal legal service.
It's got to change, it's got to stop, it's got to be admitted, and it's got to be expunged.
In 2014, Victoria became the first state to erase the criminal records of men convicted of having gay sex. The move ended decades of anxiety for countless men who were prosecuted for homosexuality. Andrew Giacomos says it's not too late for the government to grant the Indigenous community this same justice.
I would like to think that the government, with the evidence it already has, and the advocacy that they should receive, that they should consider expunging the records of children who've got criminal histories for being children in care.
Unlike in other states and territories, Victoria allows old or irrelevant records to be released. This means that for people like Larry Walsh, the anxiety of being treated like a criminal will continue to follow them.
They had to live with thinking, why is the universe against them? Because they don't even know that they've got a criminal conviction. Someone needs to admit wrongdoing was done.
While the research was conducted in Victoria, many case studies from across the nation have come to light, suggesting this systematic failure is more widespread. With the issue now raised, Larry Walsh has found some answers. But can this rectify the damage done from the injustices of the past?